I'm Ben Meiselas from the MeidasTouch Network. Following Donald Trump's criminal indictment by a Manhattan grand jury, there have been a lot of people talking about the intent element of Donald Trump's crime, because in any criminal case, you have to show intent. But folks, in my opinion, there is smoking gun evidence of Donald Trump's intent, and that smoking gun evidence comes in the form of testimony by the former CEO of the National Enquirer, David Pecker. Right? There was a reason why last Monday, David Pecker was brought back before the criminal grand jury, and then they subsequently indicted later in the week. Because ultimately what David Pecker is aware of is the conspiracy with Donald Trump to engage in this catch and kill scheme whereby the National Enquirer would try to find stories that were unflattering to Donald Trump leading up to the 2016 election, to try to buy the rights to those stories and to kill those stories so that those stories cannot be reported about. And why was it being done? It was being done at the direction of Donald Trump and in coordination with Michael Cohen, because they didn't want unflattering stories, bad stories to emerge leading up to the 2016 election. By the way, I think David Pecker will have direct testimony that that was the plan. The plan specifically related to the election. That's what Donald Trump was worried about. But enough of hearing it from me. I want to share with you three experts right now discuss that evidence, the evidence of intent regarding the National Enquirer's conspiracy with Donald Trump, and why the evidence of the National Enquirer's conspiracy is so important. So the three guests we have is Elliot Williams, who's a CNN legal analyst, who also served as a deputy assistant attorney general in the Obama administration. We also have Norm Eisen, who was the co-counsel of the House Judiciary Committee during the first impeachment and trial of Donald Trump in 2020. And then finally, Harry Litman, a former top federal prosecutor as well. This is through Harry Litman's show, Talking Feds. By the way, you should all subscribe to Harry Litman's YouTube channel, Talking Feds, as soon as you're done watching this video or whenever, because Talking Feds is part of their YouTube channel, is affiliated with the MeidasTouch Network and part of the MeidasTouch family. So all the Meidas Mighty, make sure you subscribe to the Talking Feds YouTube channel. But without further ado, watch this incredible discussion between three of the top experts: Norm Eisen, Harry Litman, as well as Elliot Williams. Play this clip.
And how are they going to go about proving beyond a reasonable doubt, or Trump injecting a reasonable doubt into the question of whether the payouts and the like were done with guilty intent to evade the law?
Let me say this. All I'll say is this. If you remember the Grinch at the end of the movie, his heart, although this as the one Gentile on the call, I'm sure you still have seen the Grinch film, but his heart grows 3 sizes at the end. Norm Eisen's heart grew 3 sizes when he knew that the first question, or now the first question is on the state of mind, intent. I'm going to turn it over to my friend Norm Eisen, who the heart, because I know this is his bread and butter.
He is the holder of the Norm Eisen freestanding chair of guilty intent in the whole U.S. of A.
For viewers should know Norm thinks about this very question a ton. So
incessantly. Well, that is the nicest comparison to the Grinch that I have ever received personally.
Have there been many?
Undoubtedly, in my long legal career, there have been some, even if they're not coming to mind. I think that the intent question is going to require Bragg to go back to the genesis of this hush money scheme as it relates to the 2016 election, which is August 2015, the meeting, Trump, David Pecker, Michael Cohen, and Trump asks Pecker what he can do to help him if there are scandals that seem to be emerging. And Pecker offers and Trump accepts to use the National Enquirer to pay for these scandals and then to kill them.
Let me stop you there. We're gonna keep going on this, but Pecker offers and Trump accepts. Sounds like conspiracy to me. Do you see that as being the framing device of the indictment? Either of you?
Well, I've started talking, so I'll let Elliot answer on conspiracy.
Well, I mean, look, that is the essence of a conspiracy. It's, right. Do you wish to join in this agreement with me? Yes, I do. Let's take a step toward it. And that is the formation of a conspiracy. And it could be. Now,
Pecker, of course, the last witness in the grand jury. Yeah.
And let's add another point on top of that, something we've talked about, Norm and I talked about on air the other day, which is this idea of Pecker can potentially be used as direct evidence of any number of the crimes, of potential crimes. Again, we're still learning, and we'll learn more next Tuesday when this all comes out. Direct evidence, but also perhaps pattern evidence, which can come into court under certain circumstances, that a defendant engaged in the same conduct over an extended period of time, even if those other instances are not charged in an indictment. So it was interesting seeing David Pecker come and show up at the end as a witness, because you could sort of try to unpack why he was there, but there's a few different reasons for his testimony, possibly.
Yeah, back to you. Okay.
All of us have spent a lot of time in courtrooms, and in terms of Pecker as the next to final witness, because we know there was some other mystery final witness who showed up on Thursday before the indictment was voted by the grand jury. When you try a case, you want to have that sense of closure for the jury. So to go back to the beginning of the conspiracy, and to have Pecker as the penultimate witness to kind of tie things up in a bow, I think is wise, because really that gives you the intent that you need under New York law. What you have to have for this books and records violation of Trump repeatedly booking hush money as legal fee repayment to Cohen, you need to have the intent to defraud. And here it was the intent to benefit the campaign without accepting unlawfully large and corporate contributions or impermissibly large contributions from an individual. And so I think that's where you start. You've got to show, and there's going to be a fight about this intent issue, including do you have to show pecuniary loss, that there was an intent to rip somebody off financially. I don't think that's the law in New York. I think that Trump's intent was made clear. And then the last thing I'll say on this, this is not going to be a case just about Michael Cohen's testimony. Michael has been rock solid with me since I interviewed him at the beginning of the impeachment. He hasn't wavered on this hush money stuff. But there's a ton of corroboration for Cohen. And Pecker's testimony about this meeting in which the plan, the scheme, the conspiracy was formed is going to be very, very important. And there's documents and texts and emails and signed checks and a lot of other corroboration. So I think they appear, we'll see, we'll get the next clue when we get the indictment. But I think there's good, strong, multi-dimensional intent evidence.
Wow, what an incredible analysis that they gave you. Also, remember, check out the Talking Feds YouTube channel. Subscribe there as well. Tell Harry that the MeidasTouch, the Meidas Mighty, sent you. Make sure you head over there. Hit subscribe to this YouTube channel. We're on our way to 1.5 million subscribers. We appreciate you. It's free to subscribe here. Check us out at Instagram. Search MeidasTouch. Check us out on any audio podcast by searching the MeidasTouch podcast. Until next time, I'm Ben Meiselas. Thanks for watching and hit subscribe.
Lock him up! Indictment season is upon us. Celebrate with the new Indictment Season t-shirt and v-neck exclusively at store.meidastouch.com.